Bethany, can you please explain to me the link between Dementia Action Week and private client legal services?
Yeah, so I think the first thing to debunk is the whole idea of what private client actually is. So private client is any legal work that is not related to businesses. So we don't do anything with corporate entities, and it's basically the law for people. Private client covers things like wills, lasting powers of attorney, and deputyships. And basically we are seeing a ever-growing increase of dementia in our clients, and therefore we've had to learn how to adapt our services and the legal system in general to deal with people with dementia and capacity issues.
Thank you. So can you explain to me what is an enduring power of attorney?
So an enduring power of attorney was a document that was basically the standard before 2007. So before 2007, you could only make what was called an enduring power of attorney for property and finances. So those documents were only ever designed to cover somebody's property and finances, not their health and definitely not their welfare. With those documents, they sit in storage or at the person's home until somebody hasn't got capacity. So they cannot be used until somebody hasn't got capacity, and then they are registered with the court. If somebody never loses capacity, somebody's enduring power of attorney never leaves the storage facility.
And if somebody has an enduring power of attorney and they want to activate it, how do they do that?
It's a court-based system, and unfortunately, because the documents are so old, it's a very old-fashioned court route. It's lots of forms. You have to serve notices on family members, and crucially, you have to prove that that person's now lost capacity. You then submit that application to the courts, and it takes about a month for the document to come back all registered and stamped. And that means that the attorneys or the trusted peoples or persons that the person has nominated to be their attorneys are then free to go and access their bank accounts, start looking after their money and managing their finances, but not before, crucially.
Thank you. Can you explain to me then the difference between the enduring power of attorney and the lasting power of attorney?
Yeah, so enduring was pre-2007, lasting is post-2007. So if somebody has made a power of attorney post-2007, it's going to be a lasting power of attorney. The key difference between them is that with lasting powers of attorney, it can cover health and welfare, whereas with enduring, it never was designed to. So crucially, if somebody's got a lasting power of attorney, you should be asking, has that person got one for health and welfare as well as finances? Whereas with an enduring, you can automatically assume nobody's got that access for health and welfare.
So is there more than one type of lasting power of attorney?
Yeah, and that's where lots of the problems come from, because people often think there's just the one. So with lasting powers of attorney, you have property and finances covered under the same. It doesn't matter if you don't have any property, you can still have that document. And then you also have the one for health and welfare. And crucially, the way that they work is very different. So with property and finances, if a person's still got capacity later on in their life, they can still use that document to hand over some control to their attorneys. For example, if Mr. Smith was frail and could no longer get to the bank, he could say to his daughter, who is his attorney, go to the bank, get me £50 and go and do my food shopping. She can't go and spend that money on, clothes. She can't do any more. She can't do any less. Then if Mr. Smith then lost capacity completely, his daughter can take over everything. With health and welfare, it's all or nothing. Whilst that person has capacity, nobody has the right to talk about your health and welfare and make decisions. However, if you do lose mental capacity, then your attorneys take complete control over your health and welfare, make decisions such as care homes, treatment, and also crucially, end of life decisions.
Can you just tell me, with the one for health and welfare, who makes the capacity assessment? How does that happen?
Yeah, it completely depends how you're doing it. So if you go via a solicitor or a legal professional, often we will make a judgment call as to the person's capacity, and then we act as what's called the certificate provider that confirms that our client has got that capacity. If you're doing it by yourself, which is completely fine, you need either a friend or somebody you know of more than 2 years to confirm that capacity, or a doctor needs to confirm that capacity. However, I do emphasize, that capacity assessments are outside of the NHS remit, and therefore doctors will often not be certificate providers for free. They will often charge for that service.
Thank you. So if I have an enduring power of attorney that I've had for a long time, can I change it, and how do I do that?
Yeah, so it's something we're seeing more and more. They kind of come to life quite a lot. So you can do what's called a revocation of an enduring power of attorney. It is a legal deed. It's just a piece of paper, but it is a legal document. And it confirms that when you made your enduring power of attorney, say in 1998, that was your intention, but now you no longer wish for that document to be valid, and we basically revoke it. And then you're completely free to go ahead and make lasting powers of attorney.
Thank you. When do lasting powers of attorney end?
Yeah, again, a very big misconception. So lasting powers of attorney, they last for your lifetime. That means that, unfortunately, when somebody passes away, their lasting powers of attorney fall away with them, and somebody's will comes to the surface. And one thing that we like to debunk is that an attorney is not the same as an executor. That is not the same legal term. Often they're the same people, but I always caution people to not automatically assume that they are somebody's executor just because they were an attorney.
Thank you. We often hear the word donor when we talk about lasting power of attorney. Can you explain to us what a donor is, and can they make it the power of attorney now and amend their attorney in the future?
Yeah, so again, donor is a legal term, which is really frustrating because it's used quite a lot in this space. So donor basically means the person making that lasting power of attorney. So I like to say the person donating the rights to make health and welfare decisions or property and finance decisions on their behalf. Often, yes, we do see lasting powers of attorney made in, for example, 2008, that somebody then comes in and says, oh, unfortunately, my loved one's passed away, or they're getting elderly and they no longer feel able. All it is we have to basically redo your lasting powers of attorney. You can't just amend them like a will. So it is a fresh document set. But again, the courts are getting quicker and quicker at processing those amendments and sorting those out for people.
Thank you. Why do you recommend that those looking to make a lasting power of attorney seek legal advice for this?
I think mainly because they're quite easy to get wrong. I think I've seen in my experience, lasting powers of attorney without instructions and preferences on the specific page. And basically, if you don't have those in there, it restricts the powers of the attorney. And therefore, I've had loved ones come in and say, oh, I would like to do X with my husband, my wife's finances. And I have to say, I'm really sorry, the clause isn't in there to allow you to do that. So I always recommend legal advice to A, make sure that everything you want to hand over power-wise is sorted. B, to make sure that the certificate provider who is confirming that you have capacity is, I'd say, reliable and is willing in the future to confirm you had capacity when you made that document. And also the signing process is extremely complicated. They are long documents and everybody has to sign at a specific time. So we oversee that complete process. It takes the stress away.
Thank you very much. Thank you. Can a donor, so as in if I wanted to make a lasting power of attorney, but had been deemed not to have mental capacity or had fluctuating capacity, can I make a lasting power of attorney?
The answer to those questions depends on which one you're talking about. With fluctuating, if we are concerned as professionals that somebody maybe has good days and bad days, we will often get what's called an independent capacity assessor in. They're often independent social workers, lovely people. And what we deem and what we say is that they have enough experience to determine if that fluctuating capacity is at a level where it's too far to not have capacity, or maybe they're just having a bad day when they came in to see us, and they'll then confirm if we're okay to proceed. Unfortunately, if somebody doesn't have mental capacity, so say they're further on that dementia journey, we can't do lasting powers of attorney. Lasting powers of attorney can only be made when somebody has capacity. If you don't have capacity, it's what's called a deputyship order.
Thank you. So can I ask you to explain what a deputyship order is and how it differs?
Yes, so deputyship orders are basically, they are court orders. Lasting powers of attorney are court documents, but they're not orders. So with a deputyship order, what that means is that somebody, for example, the children of their mother or father who hasn't got capacity, applies to the court and is saying to the court, my loved one does not have capacity. Please, can I have the right for all of these reasons to look after their property and financial affairs? The other key difference is that the evidence you have to provide for a deputyship order is a lot higher, because the courts have to basically take a risk on appointing somebody as a deputy. And finally, it's a lot more expensive, deputyship orders, because of the amount of work involved. If you go through a professional, which I always recommend because I even find them confusing at the best of times, they can run into the thousands because of the amount of work required to basically pass the court's threshold. And finally, they're taking a long old time to come back from the court. Lasting powers of attorney take about 12 weeks on a good month, whereas deputy orders are taking about 18 months door to door. So there is a big difference in terms of the realistic timescale that you can be expecting to have access to your loved one's finances.
Thank you. A question I'd like to ask is, we hear a lot about advanced directives, and we also come across people who perhaps haven't got the lasting power of attorney for health and welfare, trying to understand, second guess what their loved one might want to happen.
Yeah.
Can you explain, do advanced directives or wishes about what you want to happen get incorporated?
Yeah, so if you have a lasting power of attorney, we can incorporate wishes in. So often there's a clause that we add as professionals that says you wouldn't want to be on a ventilator, you wouldn't want treatment if you were brain dead and things like that. Very normal. So yes, we can build that in. If for whatever reason you can't do a health and welfare, maybe you don't have people to appoint, or you don't want to do one, advanced decisions or directives, the two are conflated. They're very good documents, because what that is that's again a legal deed confirming basically what you would want to happen to you if you no longer had capacity. That can be as basic as I would like to stay at home for the remainder of my lifetime, all the way up until if I was brain dead, I would like the ventilator to be switched off. Crucially, we're seeing it more and more with people who don't have anybody to appoint in this country, but have relatives abroad who they would like to be notified if something happened to them. We can do that. And that's actually a very good safeguard for then, if that person does go into hospital, for the doctors to at least have some sense of what they need to do, what they should be treating. It is a grey area, and I don't think any professional is under an illusion that it's perfect, but it is getting there in terms of advanced directives being respected and also crucially being understood.
Thank you. As a solicitor, in your professional capacity, you are working with a wide range of clients, many of whom have life-limiting conditions, many of whom may be living with dementia. Any final words of wisdom or advice for people or for their families in terms of what they should be considering?
My number one tip is don't be scared of us. I think the law is quite a scary thing. The media makes us look like we all do criminal law and we're in court all day arguing. We're actually normal people that do completely understand that, you know, cognitive impairments and end of life, kind of terminally ill people are out there. And therefore we want to help you. And I personally have a very high percentage of clients with dementia who I'm very proud to be acting for. And they wouldn't have got the help they needed if somebody wouldn't have reached out for them. So all you can do is reach out. We will say no if we think the answer is no. Additionally, I think we as a society are very scared about talking about losing capacity, being poorly, and also passing away. And I think that something we all want as a profession is to kind of end the stigma. There's nothing wrong with doing this while you're young and you're fit and you're healthy. Martin Lewis recently told a 25-year-old to get a lasting power of attorney. So I think engage with it younger and actually start having those conversations with your loved ones. And finally, if you're unsure, don't make the legal document. I've seen quite a few where people have entered into decisions that I don't think they understood. And in a way, our answer is, if you're unsure, take a pause, pick up the phone to a solicitor and ask the question. Most solicitors will offer private client services. It's kind of a bulk of any law firm's services. So reach out, ask the question. We're here to help. And fundamentally, the law is there for you. The law is on your side, and therefore, so are the solicitors.
Thank you very much for your time
No
today.
worries.
Thank you.
No worries.